Okay, thank you. It's on. Colleagues, good afternoon. Welcome to the session after lunch, the most exciting session of the day, where everyone is rejuvenated and ready to go. I am Shalane Udit, for those who don't know me. I'm the General Secretary of the GPSSBC, the General Public Service Sector Bargaining Council in South Africa. It is my absolute pleasure to introduce a fellow South African, Dr. Kamalesh Newaj. She is a senior lecturer at the University of Pretoria. She specializes in labor law and social security law and teaches at both a graduate and postgraduate level. She has published numerous articles, and she is also an advocate of the High Court, an associate member of the Pretoria Society of Advocates. She's also a fellow public servant from ex-public servant from South Africa, and our association with Dr. Newaj goes back many, many years, and we're very proud to actually be part of this process in terms of being here for your paper as well. So allow me to hand over to Dr. Newaj. She's going to give us a presentation for about 20 minutes, and then we will take a discussion. Thank you.
Okay, thank you very much. So today I'm going to be speaking about the rights of Uber drivers. So for me, this is a very important topic because, as you know, Uber offers services in many countries globally. But in Africa as well, there are many countries that make use of the services of Uber, such as Nigeria. Oh, sorry. Okay. Right, such as Nigeria, such as Kenya. Unfortunately, Uber isn't offered in Mauritius, but as I say, it's still an important and relevant topic to Africa as well as beyond. Now, my discussion today is about Uber drivers, but obviously it doesn't only affect Uber drivers, it affects everyone performing platform or gig work. And some estimates have suggested that by 2025, digital platforms could account for 1/3 of all labor transactions worldwide involving millions of workers. So what I'm going to do is I'm going to just start off by sketching the legislative framework in South Africa. This is important to understand and to give context to the Labour Court decision of South Africa that I will be discussing. And thereafter, I'll be looking at the position in the UK. There was a court decision not so long ago, the Supreme Court of Appeal. So I'll be discussing the UK decision and then looking at what parallels South Africa can draw from that. So to start off, we have a constitution in South Africa which is very progressive, and it's based on a number of fundamental principles and fundamental values, one of that being the promotion of social justice. There is also specific labor rights provided for in our constitution. Importantly, everyone's right to fair labor practices. And obviously, in interpreting South African legislation, it has to be done in a manner that gives effect to the spirit and the purport of the Constitution. So moving on to our labor legislation, the most important one is our Labor Relations Act, and one of its fundamental objectives is to give effect to Section 23 of the Constitution. Now, one of the important protections provided for in our Labor Relations Act is the right not to be unfairly dismissed. However, in order to gain access to this right not to be unfairly dismissed, one has to be categorized as an employee. So as a starting point, we have a definition of employee in our Labor Relations Act. If we look at the definition, it's fairly broad in nature, but it does exclude independent contractors. There is, however, a part B to our definition that speaks to any person that in any manner assists in carrying on or conducting the business of another. So apart from our definition of employee, which as I said is quite broad in nature, we also have other safeguards in our labour legislation, and these all work together in order to interpret who gets protection in terms of our labour laws more broadly, and also to root out disguised employment. So two of the other legislative aids that we have is our presumption as to who is an employee, that is stated in the Labour Relations Act, and then we also have a code of good practice on defining who an employee is. So our presumption tries to make it easier for employees to prove that they are employees because it lists a number of factors such as supervision and control, economic dependence, which if they can prove just one of those factors, then they are presumed to be an employee. And our code of good practice, again, also seeks to give effect to that presumption, provides more clarity on that, and provides more certainty in awarding or helping to identify whether someone is an employee or not. So apart from our legislative framework, starting with our Constitution and then our Labour Relations Act, we've also had assistance from our judiciary, where they have sought to develop our law in this regard. And from our judicial decisions, there are basically two important tests that have come out in identifying whether someone is an employee or not. So one of the tests is the dominant impression test, where they would basically look at all of the factors and then assess whether the dominant impression that is formed is that one of employment or of independent contracting. The second test is the reality test, and that was set out in the court case of State Information Technology Agency, and there they looked at three important factors. So, was the person subject to supervision and control? Were they economically dependent? Did they form part of the organization? Okay, so all of these tests basically seek to establish what is the true nature of the relationship. So irrespective of what a contract might define a relationship, these tests are basically used in order to establish what the circumstances were and whether one could say that the person is an employee or not. So I just wanted to mention that our courts have for many years, both our labour court as well as our labour appeal court, stated that when you're determining whether someone is an employee or not, the emphasis is not on the employment contract, but the emphasis is on the employment relationship. So someone can be an employee even if there's no contract in place, and likewise someone could be an employee even if they were categorized as an independent contractor in a contract that exists. So the question that came before the CCMA in South Africa, which is our conciliation, mediation and arbitration, was whether Uber drivers are employees or not. So basically this case came about because certain Uber drivers were so certain Uber drivers were deactivated from the Uber app and they instituted an unfair dismissal dispute. So obviously the first thing that Uber argued was that these are not employees, these are independent contractors, and this is clear. This is the contract that we signed, and also if you assess the relationship that exists between Uber and the drivers, you will see that it's one of independent contracting. So they pointed to things like there's no obligation on Uber drivers to use the app. They can work for other employers, they can work for competitors. And they said that the fee that the drivers paid to Uber was merely compensation for the drivers using the Uber app. The drivers obviously on the other hand said, no, we are employees, we are subject to Uber's control. Uber can deactivate us at any time and therefore prevent us from earning a living. And there were other issues that they raised that they said pointed to an employment relationship. So the decision of the CCMA was that Uber drivers were employees. Okay, so they said, if you look at how this whole business operates between Uber and between the drivers, it cannot be said that Uber drivers are running their own businesses or that they are independent contractors. And they also importantly said that even though Uber BV was the one that provided the contracts, was the one that set the fares, was the one that controlled the app, they found it was actually Uber SA that was the employer. And the reason for this is because they said that it's not proper for an international company to avoid liability. So, for example, they said that the relationship between Uber and the drivers, Uber BV and the drivers, was an anonymized and distant relationship. So Uber drivers didn't really have contact with Uber BV, which is the party with whom they signed the contract. Their interactions were with Uber SA. And therefore the CCMA commissioner said, but if I were to hold Uber BV to be the employer, it would be difficult because there was a provision in the contract that said that if Uber drivers had a dispute with Uber, they would have to refer it to the Netherlands and that those laws would apply. So the CCMA commissioner found that that would not be doing justice because you have to avoid severe disadvantage to the drivers. And that's when she brought in the whole issue of social justice imperatives and the fact that you've got to protect the weaker party in the relationship. So that was the decision of the CCMA. And then, quite surprisingly, I think for me, and as well as other South Africans or other people in this field, was that the Labour Court then overturned this decision. Now, the Labour Court focused very much on the distinction between Uber BV and Uber SA. So, firstly, they looked at the workings of this business. What was Uber SA's role? What was Uber BV's role? And they, though not directly stated, they seem to accept that one could say that Uber did control and supervise Uber drivers to some extent. There may have been some integration into the organization of Uber drivers. There may have been some economic dependence. But for them, they felt that, or the Labour Court judge felt, that these factors couldn't be attributed to Uber SA. So because this dispute was now between Uber SA and the Uber drivers, the Labour Court came to the conclusion, unlike the CCMA, that they could not attribute employer status to Uber BV. However, they did make the point that they would not go into whether Uber BV was the employer because this was not what they were called upon to do. So they basically left this question open. Is Uber BV then the employer? There was then a subsequent decision by the CCMA, which came after our Labour Court decision, and there they had to grapple with the question of whether Uber BV was the employer. Okay, so there, they relied on a test known as the locality of undertaking test, which is basically that because the undertaking of the organization was not within the borders of South Africa, that meant that the CCMA could not have jurisdiction, because Uber BV is based in the Netherlands, and therefore they just closed down any authority that they had to deal with this matter. So where does this leave Uber drivers in South Africa? So basically it leaves them with no recourse. We have the Labour Court that says they are not employees of Uber SA. We have the CCMA that says they can't deal with whether they're employees of Uber BV because the CCMA doesn't have jurisdiction. Now, in my view, I disagree with the decision. I definitely feel that the Labour Court could have done more. Here we're dealing with platform work. We know that this is a new form or type of work, and we know that it doesn't operate in the same way as standard employment does. So I think that the Labour Court could definitely have been more progressive in their approach. They could have taken account of social justice imperatives. They could have looked at our definition of employee more broadly, and also they could have possibly found that there was joint employment, or that Uber SA and Uber BV were joint employers, instead of just ruling out any recourse for these employees. And joint employment is a recognized principle in South African law, and it was, this was the stance that was taken in a case in New Zealand that came after the South African case. So I think it was in 2022 that New Zealand ruled on this matter, and they found that Uber BV and the joint affiliate were actually joint employers of the Uber drivers. So in terms of the UK position, so I've just sketched out there very briefly what their law is. So they had to decide whether Uber drivers were workers. And I guess the important point from that slide is what the definition of a worker is. So it's basically anyone that works under a contract of employment or any other contract whereby the individual undertakes to do or perform personally work or services for another party if the other party is not a client or customer of the business that that individual is performing. So it excludes independent contractors or those who are self-employed, and that's quite similar to the South African definition of an employee that excludes independent contractors as well. So in the UK case, the matter started off in the employment tribunal, and where they found that the drivers were workers. Obviously Uber appealed. It went then all the way up to the Supreme Court of Appeal. And on appeal, Uber continued with its contention that the drivers were independent contractors, and that was clear from the contract that had been entered into. So the SCA, they said that the starting point would be, the SCA considered Uber's argument that the starting point to deciding the matter should be the contract itself. Firstly, the SCA disagreed on that point. They said that the contract can't be the starting point, because if you enter into a contract with someone as an alleged employer, and you say this person is an independent contractor, and we use the contract as the starting point, then that means you're allowing that person to determine the employment status of the alleged workers. So they took heed of the case that's called the AutoCleanse case, and there it was stated that the true agreement will have to be assessed from all of the circumstances, and the agreement that is concluded between the two parties is only one aspect. So So a similar type of test that we use in South Africa to unearth what is the real substance of the relationship between the parties. The SCA then went further. They looked at the statutory definition of a worker and the factors that pointed towards a person being a worker, and the main ones being dependence and subordination. And they then came to the conclusion that while the drivers could choose when they wanted to work, which gave them a substantial measure of autonomy, so they recognized that Uber drivers do have autonomy and independence. They found that this didn't mean that during the times that they did work, they could not be classified as workers. So the SCA then looked at or referred to 5 factors that was discussed by the employment tribunal when they found that the Uber drivers were workers. And those are the 5 factors. The remuneration paid to the drivers was fixed by Uber. The contractual terms were dictated by Uber. Uber exercised control over the drivers, because when a driver was logged onto the app, they could not just, while they could refuse requests, if they did so, they would have basically been penalized for this. The other 2 was the fact that Uber exercised control over the way drivers delivered their services, so the types of cars that they could use, the fact that Uber provided the technology, the fact that if they didn't maintain a certain rating, they would then be deactivated. And then the last one was that Uber restricted the communication between the drivers and the passengers that these drivers transported. So ultimately they found that the only person that was benefiting from this relationship was Uber itself, because they benefited from customer loyalty and goodwill. So the SCA decided or agreed with the employment tribunal that Uber drivers are workers. Now, I've already said to you that our Labour Court has said that Uber drivers are not employees, albeit employees of Uber SA. So I think the UK decision is an important one for South Africa going forward in dealing with further cases from Uber or dealing with other cases from other forms of platform work. I think that we can apply the principles that we use in the UK, because I think the tests that we use are in any event quite similar. And it's also important to note that in the UK, the courts were not obsessed with this distinction between Uber BV and Uber SA as we were in South Africa. They found that Uber London was the employer, not Uber BV, and this is despite the same characteristics that we have in SA that deterred the Labour Court from finding that Uber SA was the employer of the drivers. And this was things like who sets the contractual terms, who decides on the fares, who controls the app, right? These are all things that are done by Uber BV. But yet in the UK, they found that Uber London was the employer. So in conclusion, I would say that our legal framework in South Africa is definitely broad enough to make a finding that Uber drivers are employees in South Africa. But I think at that point, when the Uber case was decided by the Labour Court, the judiciary just did not have the necessary resolve to apply the law purposively as was done in the UK. Thank you.
I think if you could just state it, Dr. Newaj. Colleagues, allow me to start by thanking Dr. Newaj for the very interesting presentation, very thought-provoking. I'm going to open the floor for some discussion. I don't necessarily want it to be a question and answer, but we can really have a discussion over the presentation. And then if there's a direct question though, please feel free to raise it. But if there's comments from the floor, we'll take them and start. Can I get an indication? Okay, I've got a hand here. Any other? Okay, we'll start with you. Georgina.
Thank you for a very insightful presentation. And another problem that Uber drivers are faced with is the forced arbitration clause in the contract, right? So, I mean, the problem is we're not seeing these cases going to the CCMA and coming through the labour court. So, do you think there will be space in the future to reconsider the judgment because of that provision?
I definitely think there will be space in future. I think perhaps if this judgment, the Labour Court judgment, was taken on review, on appeal, there may have definitely been a different answer. Because I think the CCMA did make very important pronouncements. You know, she did explain why she's interpreting the legislation broadly. She did touch on the social justice imperatives. And the fact that, I mean, you expect Uber drivers to now go and deal with their claims in the Netherlands. I think that's really inaccessible and impractical. And I think from what I was reading, in Canada, when they were dealing with this case, when they looked at that provision that says you must refer your dispute to the Netherlands, they actually said it's actually unconscionable and reprehensible, and that that type of clause should never have been or should not be in the contract that's concluded between Uber and the drivers.
Any follow-up, or are you comfortable? Sure. I'm just going to hand it back now. I'll come to you. Ma'am?
Thank you for that. Thank you for the presentation. I was just wondering because there was some time that Lady was interested in litigating further these cases, having like a class action lawsuit. I'm not sure where they are with that. Like I've been waiting and wanting to hear like where they are with that. Is that like something, information that you have? But also, it's quite interesting to see how digitalization is changing the world of work. And also when it comes to labor laws, and the question is always, should we interpret the existing labor laws to cover the new forms of work? Or should we come up with regulations to cover now this new type of work? So that's one bit of the question, because when you look even at, for example, Facebook was sued the other day in Kenya, and the argument was the same as the one for Uber BV, and was saying that they cannot actually be sued in Kenya, but fortunately the court ruled that they can actually be sued. We are closely watching how the case will go, but these are the types of jobs that we are seeing that are being created, especially in Africa. And you rightly say, like, having to sue in Netherlands does not really make any sense. One, because also the right to access to justice can be denied from that perspective, but also probably even like affording lawyers who can actually represent you there, that's also like another issue altogether. So I would like to hear more about what you would say, because there are some arguments that say that no, the laws that we are having are still like very much relevant. What we have to do is just extend protection. But there are some who are saying that these new forms of work need like specific regulations, looking at them because they have some certain kind of peculiarities. So I would like to hear what you have to say about that. Thank you.
Thank you. So firstly on the class action suit, so I did follow that, especially when the SCA decision came from the UK, then there was a lot of hype about the South African Uber drivers initiating a class action. It hasn't landed in the courts yet, so I'm not sure if they actually decided to pursue that class action or not. But there's also been moves from our government to get involved. So there was discussions about our Department of Transport coming together with trade unions, etc., to see if how can they accommodate Uber drivers. So I think that's an ongoing process as well. The question about whether the law is sufficient or whether we need more. for new forms of work. From a South African perspective, I believe that the law as it stands is actually adequate to cater for Uber drivers and other forms of platform work. Our laws are very progressive, and if you take the Constitution itself into account together with the provisions of the Labour Relations Act, I think a strong case can be made that Uber drivers are employees, just rely on the law as it stands. However, because it's such a controversial issue and because different courts come to different decisions, I do think it would be a helpful tool if we could then come up with legislation that would cover these specific types of work, platform work and other new forms of work specifically. Then I think there would be more clarity and we wouldn't have to try and ask ourselves, will this judge interpret the law purposively as opposed to another judge?
Okay, thank you, ma'am.
Thank you, Mike. I just want to first of all thank you for a very good insight into the way the different courts have applied this to the Uber drivers. And I was just thinking, just as you were saying, should these Uber drivers be left unprotected because they cannot find protection in the courts? Because you see, one thing we always have to look at the imbalance. You would find that the employers, Uber, would have very good lawyers who would take all the jurisdictional, the technical issues on board. And courts, even though they are progressive, they can be progressive or use broad interpretation, but sometimes they're limited insofar as the way they would want to apply and go progressively, especially when you have such force of lawyers. So I think it would be helpful, for legislation to come in, for regulatory frameworks to be properly established so that when these companies come into the country and want to do business, they have to insist that access to justice should be easier for those who are employees or who are benefiting from those contracts. Thank you.
Yes, thank you for that comment, and I agree fully with what you said. And as you say, it's always about the inequality. I mean, Uber is this giant. It has so much of resources at its disposal, and then you have the Uber drivers who now have to go and seek a remedy in the Netherlands. And I agree with you, and I think the way in which I've answered the previous speaker was to say that having better regulations in place that governs these specific aspects of work will go a long way in avoiding interpretation and interpretation of the law, which could lead itself to different interpretations.
Yeah, I fully agree as well with the comment. I mean, this is about protecting vulnerable workers, and it's the average Joe against the big corporate. So the only access to justice may be through legislation and regulation. So, your question?
Thank you. I want to just debate with you. I'm from a school of thought that when two lawyers agree, one's not thinking. So let's disagree.
Are you an attorney? Do you want to discuss? Yeah, there we go.
Now, my question is, I think your view, your interpretation of labor courts is a bit narrow in the sense that if I look at the factors in Section 2A, we may just be focusing at one factor as opposed to the 7. I understand that the present one obviously is enough to trigger the presumption, but there are other factors. And for me, it doesn't fit in neatly that Ubers may be said to be employees, given if you look at the dominant impression test, the only thing that the court focused on was just, look, you have no control. We can switch off the control anytime. But are they economically dependent on Uber being? The answer is no, because they can still run their own operations, they can still be employed elsewhere. Are they a physical part of the organization? The answer is no. So I think, for me, looking at it from a perspective that we're looking at today is a little bit of emotive, not a legalistic approach. And it could be very well that it's a network issue, that let's just go back and redraft and just say, we are removing the Section 2 presumption, let these guys be employees for social protection benefit. Otherwise, the lawyer, and as a legal person, there's nothing wrong with the finding of the legal court, in my view.
Okay, of course, there are people that differ with this view, and one of the main contentions is that Uber drivers, a lot of them don't only work for Uber, they work for many other companies as well, other other companies that run transportation services through apps like Bolt and so forth. So yes, there is that argument, but I think at the end of the day, a lot of Uber drivers do depend on Uber to earn or depend solely on Uber to earn a livelihood, or depend partially on Uber to earn a livelihood. Now, if Uber were to deactivate them from the app, you are taking away their ability to work and to earn a living, whether it was you were solely reliant on them or you were only partially reliant on them. And I think there was an interesting article that I read by Detroit, and he was explaining how one would define an independent contractor in a platform economy. It would be one who would be able to set their own fees, who would be able to interact with the passengers in order to build their business and to grow their business. So if Uber was just there, to provide the app, they, for example, said, I sell these apps to the drivers, or I hire these apps to the drivers, you pay me a monthly fee for the use of the app. But then it's solely your responsibility, to service the clients and so forth, and there's nothing preventing you from communicating, from building relationships, from setting your own fares for the transportation that you provide. I think all of that are quite strong indicators that Uber then, or the drivers, are not independent contractors. Because at the end of the day, it's still Uber that's controlling this app. There are other ways that they could have gone about making money from their app without basically using the drivers in the way that they do. And I think that definitely we can't say that the drivers are not an integral part of Uber's business. Because Uber, the only way Uber's making money is by using these drivers to perform a service for them that benefits them. So I think, while I respect your view, I also think that there are a lot of indicators that show that they're not typically independent contractors. Like you say, they're not employees because there are many boxes that they don't tick. But I think if we look at it, or we look at it on the other side, the same can be said, that they don't tick the boxes of those characteristics that a typical independent contractor would tick.
Okay. Colleagues, thank you very much. Another round of applause to Dr. Newaj. I think this debate is going to go on for some time to come as we continue to have the employment status evolving and platform work becoming more and more prevalent. So I'm sure in future conferences we will look forward to looking at the divergent views again. Thank you so much, Dr. Newaj. Thank you, colleagues. Let me hand over to the next chairperson.
My name is Crystal Best, and I have to say I am positively thrilled to be here. I am an attorney trainer in the United States. I work for Cypharth that work in Chicago, and we provide trainings to both employers and employees in all aspects of the labor workforce. And so I'm happy to be here chairing this particular conversation. We are talking this afternoon, I'll just come up here. So our subject today is the common fate of trade unions in the digital transformation of labor and the need for global solidarity. And so I'm going to introduce our esteemed speakers at this time. And this is fascinating to me as I think about labor unions in the United States and what's been happening within that industry. I shouldn't call it an industry, but within that context. To tell you a little bit about our speakers briefly, and I'm going to ask you for help. We have two representatives from Solidarność, Poland, at the NSZZ. So we have Mr. Stawomir Adamczyk, and we have Ms. Barbara Surdykowska. And I don't know, I guess this mic is also, I'm going to do a really quick intro just in the interest of time. But Mr. Adamczyk is responsible for coordinating the cooperation of various industrial sectors within the NSZZ Solidarność trade union. The first independent labor organization in the communist bloc countries of Central Europe that initiated a process of democratization throughout the region, and I'll let him go more into detail. I'm also really pleased to introduce and honored to have Ms. Surdykowska. She is a legal advisor to the NSZZ Solidarność trade union. And again, it's the first independent labor organization in the communist bloc countries of Central Europe. And so what I will do is I'm going to pass it off to them at this point. And I don't know who's coming up first or if you're going to do this together. And from there, we will open up the floor for conversation and discussion.
Okay. Good morning for all. I see that you are look at this title and you think that this is a title not too serious, but this was not our idea that the title of the presentation was serious, because we for many years work with trade unions. We are advisors to trade unions, but we have some kind of hobby as well, and our hobby is thinking about the future of trade unions in our globalized world. And what is our idea? Our idea is that trade unions can not only survive, but to be also very important stakeholder only when they will be able to cooperate on cross-border, on transnational dimension. In such situation where they will be able to ensure proper balance between capital and labor. And we discussed this issue within our continent, in Europe. And one time we realized that we need to look more broadly, globally, and because there was possibility to visit your conference, we proposed that we present some broad description. This is what we think about the trade unions in future world, in this situation where trade unions are facing many huge challenges, including digital one. So, so maybe a few initial remarks. This is what we expect in the coming years. This is the very crucial developments on the labor markets, regardless of the countries and the continents. This is some kind, we call it digital tsunami, caused by development of new technologies, but above all thanks to dissemination or relatively cheap internet across satellites on global scale. Of course, everybody knows Starlink satellites. Somebody can say that it's too expensive still. Probably it will cost $100 a month, but there are other initiatives which probably will be cheaper. Initiatives which are oriented towards giving as much population as it's possible the cheap internet. So probably in next few years this global internet will be accessible for all peoples regardless of these continents. And this will change the way enterprises and public institutions operate, and above all, it will have an influence on the very nature of work. In our opinion, this will have a significant impact not only on workers, but also on the situation of traditional workers' representation, I mean trade unions. Because we work, as I said, many years with trade unions, and we like to work for trade unions, but in our opinion, trade unions, labor unions are very traditional, very conservative organizations, focused on jobs existing in physical space, while the development of employment through platforms will cause the dissemination of dispersed work. And in addition, the trade unions, especially in these developed countries, in Europe especially, but also in USA, they are very strongly attached to their own national systems. And it makes it difficult for them to function in supranational network conditions. And this transition to the model of transnational cooperation of trade unions is crucial for the possibility of further influence of this organization on the situation of world of work. And we see that the share of labor force is changing across the globe. Especially, development of the size of the working class is taking place mainly in the countries on the African continent. And this fact only underscores the importance of future transcontinental trade union cooperation. I say transcontinental, although we in Europe have a huge problem with developing a cross-border cooperation of trade unions in our continent. But about this maybe later. So now I pass the floor to Barbara to continue.
Good afternoon, everybody. As it was said, my name is Surdykowska, and I work as a legal advisor for Polish trade union Solidarność, which, as you know, in the 80s was the first independent trade union in Poland, and it was a past of all the political change in Central and Eastern Europe. But of course, what we all want to speak right now is not about the history, not about the past, but about the future. And as Stawomir said, we want to put into discussion the question of transnational solidarity of trade unions. And of course the question, we don't know the answer, it's a very huge question, and for sure we are not going to make any concrete answer to the problems, because we want to show that even inside European Union, where we have the freedom to provide service, where we have the freedom to provide, I will be trying to be fast, freedom to provide service, freedom to provide to free movement of workers, it's very hard to get this solidarity between the trade union, especially if we look at so-called old member states, so the country which built European Union, and this so-called new member state in Central and Eastern Europe. I said so-called new member state because the enlargement was in 2004, so it's not such a new situation. So of course, I won't have enough time to speak about the situation of the world of work, because there are many issues that already have been said during many presentations about the influence of the COVID, about the remote work. We had a panel about the remote work. Remote work is a very huge challenge for the trade union in the area of how to organize the people who are working remotely. That's why, for instance, Polish trade union will much in favor of the hybrid system of working. So you work part-time in the office, part-time at home. We know that it's the most expensive, because then the employer needs to focus on two proper health and safety workplace. But this is the only way that you can have the social connection, and the trade union can really influence, get access to the workers. Of course, I don't want to speak about declining bargaining power, and what really reason of this is trade union are lacking the method how to make this organization more interested for young people, for the women, for the people working in the sector, or is it all about the technological change? So I won't have enough time to speak about all of this. So very quickly about the challenge. Of course, the list of the challenge is not a full list of the challenge. We can speak about the platform work, and I just want you to know that right now in the European Union, in the European Parliament, we have the process of the new legislation, where we will probably have a directive with the presumption of employee status of the person working through the platforms. So as in the former presentation, we were speaking about the Uber, so it will be quite important. But of course, remember, it's still before it's not finished. There is a discussion between the European Parliament, the Council, the Member States, and the European Commission. Remote work, this is also a very huge topic. I already said a little bit, but I want just to mention a European social dialogue. So the discussion between European Trade Union Confederation, the umbrella organization which trade union from EU member states are part of, and Business Europe, the most important employer organization on the Brussels, on the European level. And right now we have negotiation about remote work. So about some new regulation which then will influence the situation in particular member states. They are so-called autonomous agreements, and I think this is quite interesting because they are not implemented by the governments, but they are implemented by the social partners. We already had a couple of these autonomous agreements on European level. The last one was about the digitalization. The one before was about aging, about active aging and intergenerational solidarity. So, digitalization of the environment. This is about artificial intelligence algorithm. Right to disconnect. Right to disconnect is also a huge topic, especially in the psychosocial risk. When you are online all the time, it's can be very harmful to your health. Aging of workforce. Maybe this is not so visible from the African perspective, but at least from European Union perspective, this is one of the hugest challenges. The changing proportion and how to develop the work environmental to the needs of all the workers. And as I said, psychological risk, this is especially in the service sector, not in the classic production sector, but in this, the present economy is rather creating workplace in the service sector. So this new challenge needs to be addressed by trade union. That's like one simple basic sentence. At least two words about Poland, because this is where we come from. So even in this very rushing presentation, I need to say a couple of words. So we have very big problem with the blurring of the employee status. So we have the, of course, employee contract, and this is people who we call under the labor code, because in Poland the labor code, the legislation is the most important source. Unfortunately, the number of the workers covered by collective agreements are really low. We are in one of the worst situations in European Union, so only in 2 member states there are less workers covered by collective agreements, which of course means that Polish trade union don't do their work right, but it also means that the public authority are not really in favor of this source of law. And right now with the collective agreement, we have a lot of hope in some other European Union legislation connected with European minimum adequate wage. I won't speak about the directive about European minimum adequate wage, but there is very interesting Article 4 in this directive telling for the first time that there is a common goal among European Union members countries to achieve 80% of the workers under collective agreements. So you can imagine that Poland, with the 25% of the workers under collective agreements, are very far away from achieving this 80%, and it will be very interesting to see if this directive and this Article 4 really change something in the member states during the process of implementation. So for the first time we will see how it's this top-down process about the new legislation influencing directly industrial relations. From the Polish perspective, it's quite important right now to tell you about the very big work shortages. And this is quite interesting from our Polish perspective, because for the many, many years we're always sending country. In 2004, after the enlargement of the European Union, for the first time, we somehow showed to the European Union that freedom of workers to perform work in a different member states is not just a provision in the treaty, but this is the reality. because a lot of Polish immigration to the Great Britain at that time used to be a part of European Union or other country. And then, right now we have a lot labor shortages, so we are in a completely different situation because for the first time we are a receiving country, not a sending country. And this is again a very big challenge for Polish trade union, how to learn, how to put enough effort, how to put enough money to organize people other than Polish nationality. And of course it's a little bit easier with the people who are close to us from the linguistic point of view or from the, and much like from Ukraine, and it's much difficult if you think about people coming from Far East or really different destinations. So, of course, I'm open to any question in the end, but this somehow is trying to show you that this challenge, which are on the labor market, are also challenge for trade union. Sławomir, you have to
Okay, next, coming back to the global vision. I'm a geographer from education, so you see this title. Geography no longer matters in the digital era, we see, but still the labor migration, physical labor migration will be a bogeyman for developed countries. But the real challenge for labor markets will be digitization. What I mean, the virtual labor market, which is not only concerned call centers or computer programmers, because there are technologies ahead of us that we are not aware of, but which will be available in the moment. I recall the film from 2018, titled Sleep Dealer. This is dystopian vision of Latin American workers operating machines in a factory in the USA with implants in their brains connected to super fast internet. So they don't have to travel to US. Nobody needs walls on the border because you can make a cheap labor staying in your country to the entrepreneur in rich country. So this is some kind of dystopia which could be a reality, and this is very much related to this what will happen with multinationals, because you should bear in mind that we have multinationals which are one of the big players around the world, and it's interesting that they have no direct obligations under international law. We have this governance gap. They are not subjects of international law because you have very soft recommendations. For example, OECD. One hard law concerning multinationals we have in European Union. This is Directive of European Works Councils, which require to establish stable procedures of information of consultation for workers within the borders of EU. And I would like to say that we in Poland used the possibility of EWCs because when the socio-economic transformation started in our country, we were treated as some kind of no man's land, because the politicians were happy that foreign direct investments came to our country, regardless of this social impact. Trade unions were very weak, the collective bargaining coverage was very poor, and only thanks to the institution in European Works Councils, we were able to establish connection with trade unions from Western Europe and try to avoid double standards, which were very often used also by the multinationals rooted in Western Europe, in the countries where European social model were developed. But these companies had nothing against this, but they used completely different standards in Poland in that time. And if you are in the topic of EWC, you have European Works Council. It's one African example because once, thanks to Polish trade unions, it was possible to establish European Works Councils in South African breweries. This is a big brewing company. Now it's sold via factories in Europe, but it was in the beginning of 21st century that we had EWC were in African company. And now the last change.
Okay, so I don't know how I will do it, but we were preparing for a little bit longer presentation, sorry about it. Okay, so the question that some of you posed at the beginning was how to build this transnational cooperation between the trade union. So very quickly about experience in European Union. We are very far away from common understanding of the trade union from the West and from the East. And of course, we have Nordic colleagues. And they have completely different view. For instance, this directive, which I mentioned, European Minimum Adequate Wage Directive, was strongly opposed by the trade union from Sweden, from Norway, from Denmark. All the Scandinavian country trade union and also governments strongly opposed this directive. There was a huge, really huge big debate in European Trade Union Confederation. So we have one example of very big clash of the view between the trade union in EU. The second big clash is connected with what Stawomir was telling about European Work Council in multinational, because some of the trade union would like to start negotiation with the central management in the multinationals. So to build supranational level of collective bargaining, not to make only collective bargaining on the national level, but to directly negotiate with the central management. And again, the Nordic trade union are strongly opposed development of this transnational company agreement, how we call this agreement which are done between the trade union and the central management of multinational company. So just two examples of the clashes between the trade union inside European Union. And then we have this bigger question, how to build this solidarity going outside European Union. And in this sense, we have this close neighborhood, and I think it's very important from the perspective of EU trade union to build the cooperation with the accessing countries. So with this, and the trade union in the accessing country. European Union is developing, it will be bigger, there will be new member states, and it's very important not to make a mistake, which was probably done in 2004, before the big enlargement, that there was not enough connection between the trade union with the country which will be a part of the trade unions of the European Union soon. So we have to make a lesson and learn how to build this connection with this country, like Ukraine, for instance, which will be sooner or later member of EU. So that's more about the question. Of course, we have. Okay, so we have not have time, so I'm not going to allow you to come here. We just wanted to show you the poster, which was about the reggae concert in.
You know, this is a sign and proof that solidarity, transcontinental solidarity, is possible, because these are posters from 1989, when socio-economic transformation of Poland started. The Solidarność, my trade unions, our trade unions, can act freely after the years of martial law, and the first cultural event organized by our union was concert with many bands from all over the Europe dedicated prisoners in South Africa. They sang Mandela Must Be Free. It was concert named Solidarność Anti-Apartheid. So it's possible. Solidarity is possible.
I think that's an excellent place to start. Solidarity is possible. We have only a few minutes, and I just want to thank you all. I'm sorry, I wasn't trying to waste you. Does anyone have a pressing question? I think we can do maybe one or two quickly. Yes. Did you want to stand and just ask? I don't know where the mics are. I'm not sure this one's working.
Right. No, thanks so much for sharing the fast-moved presentation, but there are key issues there. The first one is in relation to what you were sharing with regard to the decline in collective bargaining across to what you were discussing. But the issue would be, what could be the way forward, looking into all the technological aspects that are coming into play, and trade unions, as you said, they are still in their traditional way of doing business. But things are changing in the 21st century. So that's the first one. Then you also spoke around the issue of the last part that you spoke about transnational trade union, where I think the idea behind is how you can have trade unions maybe working together transnationally. How possible is that? Thank you.
Okay, so I would say something about the first question. I'm not going to give any new answers. We all know these answers. I mean, the trade unions know the answer. We should be more open to the young people, to the women, and to the service sector. And many trade unions are still too much focused on the classic production or on the energetical sector, mining. And the Poland is the best example. And right now, I'm not speaking as a legal advisor for Solidarność, but as a researcher, so I can step outside. And this is a very big mistake not to have a longer-term perspective, because sooner or later, all the coal mining in Silesia, this is west part of the Poland where we dig the coal, will be over, and this is obvious. And we are not trying, we are not putting enough effort to get new members outside the classic energetical mining sector.
Okay, the second question, I think, yes, as we said in the beginning, the digital change is a challenge for trade unions, and it can be threat if you permit multinationals to operate freely. But it can be some advantage for trade unions, because we can use the possibility, these technologies, to contact, to meet in virtual situation. We have Zoom, we have Teams, we have many other communications, and we used this during the pandemic in Poland, but there is nothing against to use these tools for directly communicating between you in Africa, between us in Europe, and discuss the issues looking at our face, each other, discuss the issues which are important for us. I think this is a way. Of course, the better is to meet in real situation, just like here.
I can relate to this, because in the United States, we only have about 7 states that actually have active unions, and the unions are aging and aging and aging. So I guess I have a really quick question, and that is, if in Europe and the United States, the members of the unions tend to be getting older and older and older, and maybe someone else can answer this, is that the same thing in Mauritius? Is it on the continent as well? Is it older and older? So I think if we notice that this is a collective issue globally, the aging of unions, how can we make it more relevant by using the technologies that we have? We are down to literally 2 minutes. Can we do one more question? Yes?
I have a big question.
Okay. Then shout.
My comment is, I started European law, and I've also done human rights law in Europe. It is very evident that the EU justice system has addressed most of the labor concerns that existed in Europe. What is the future of the union, given the quality of the justice system that is there within the EU countries, which actually acts very swiftly in dealing with issues of conflicts between employers and labor? And I'm aware that they are already addressing through various commissions the EU, the technology-related issues that are emerging post-COVID.
Okay, about 30 seconds.
Wow.
Thank you. I'm getting my work at it.
Okay, so if I get the question, there was a very big asymmetry between the process of economical integration and social integration. And it's changing in European Union, and it's changing a little bit right now. We have the European Pillar of Social Rights as a kind of the roadmap in the social issue. We have this directive on the European adequate minimum wage. We have some other process going right now, which are pretty progressive in the area of social issue. So we can say that there is a kind of the waking up moment after the COVID, or after and of course right now we have the crisis connected with the inflation and the cost of living crisis and so on. So you can visibly see there's this economical integration, which was absolutely priority. Right now, of course, social integration is not a priority, but it's a little bit better if you look at the last 5 years, 7 years, if you compare to the past.
But the students started to understand that without social dimension, the EU can collapse. Politicians started to understand this because we understand it very well.
Can we give our presenters a huge round of applause? They were racing. Thanks one and all. I'm going to turn it over to the next group, and once again, I just really appreciate being here with all of you.
All right. Thank you, ladies and gentlemen. I know the temperature is high outside, and I'm very grateful you can all come here to this session. So my name is Yves Jorens. I'm from Ghent University, Belgium, but long time in collaboration with a lot of African universities on that. Now I have the pleasure in presenting you, chairing this session, and in presenting you our speaker. Oh yeah, it goes bigger then. Okay, Mr. Mayenzeke Chiya, I hope I hope my pronunciation should perhaps improve. From the Student Readiness PhD at the University of Zululand in South Africa, but he was, or is, as I was informed and read also in your CV, you describe yourself as an activist, which is a very interesting matter. I found definitely if you're in social law, you should be an activist from time to time, as well for a lot of student organizations and all that. So I think he's the right person to go with you to the digitalization of the workplace, a threat to workers' rights. Give you pleasant the floor, and in the meanwhile, take notice of questions if you have, because it will be an interactive session. Please go ahead.
Thank you very much for the warm welcome and greetings to everyone. I'll be presenting on digitalization of the workplace, a threat to workers' rights. As we all know that the COVID-19 accelerated the introduction of digitalization in the workplace. Digitalization is defined as an action or a process of digitalizing into digital form. In addition, it is defined as a transformation of the work and the workplace in a way that access to internet and ICT services are introduced in the workplace. From these two definitions, we can then conclude that digitalization means the integration of digital technologies in our daily lives, and in this context, in the workplace. This paper seeks to give a general overview of the impact it has in the workplace, particularly on the opportunities and threats that it has in the workplace, particularly in the context of workers' rights, and to establish if the introduction of digital technologies does in a way or not violate the rights of workers. Now we'll start off by giving or defining this concept. It was introduced in the 1971. Now there's a slight difference between digitalization and digitization, because the latter one speaks about converting, where you are taking a picture, scanning it and converting it to a file, while the first one speaks about the introduction of devices and modems in the workplace. Now the adoption of these new technologies, particularly in the 21st century, they present a very small scale of what this digital transformation is all about. But it did not come into place because of COVID-19. The change of the workplace owes its origin from the evolution of the world, from your first industrial revolution, second, third, and now the fourth. The aim of it was to improve effectivity and productivity in the workplace. And we started to see this transformation in the 19th century by the invention of telegraphs. And after telegraphs, we then saw the introduction of modern computing and storage information and data processing in surveillance. Now this change includes artificial intelligence, surveillance. Now this change is happening in the workplace, and it was not and is not and we could not avoid it in the context that the philosophy of Marxism, particularly so on the laws of dialectics, they tell us that everything in the world or the world is in constant motion. So it was bound that the workplace was in one way or the other going to be transformed. Now you have your Global Commission on Future of Work, your ILO report on World Employment Social Outlook 21. What these reports highlight, they highlight that there is this introduction of digitalization of the workplace, and it presents challenges. And we're going to look at these challenges in a short while. Now, what then this means? It means the workers and employers, they need to re-evaluate and find a way to integrate this into the workplace. Okay, now let's go to the crux of this paper, finding balance between the two competing rights, between employer and an employee. Now, if you recall earlier on, I said that the introduction of digital technology presents opportunities and threats. Now, we'll start off with the employer's perspective, particularly on the access of data, monitoring, and also improvement of the workplace. As you all know that the introduction of digital models, they assist workers to access data very easily, and they're able to process data very easily. It then helps workers to strategize, to evaluate and see if the existing models are working or not, with the aim of improving productivity. The second aspect of it in terms of opportunities for employers is that monitoring and surveillance and personal data processing is a very important component of the employment relations. More so that the worker must know if the work is done and it's done properly. And again, in terms of legislation, employers are bound to gather information on time-to-time basis, more especially if for an example, your tax, your health status, your criminal record, and all of that. From time to time, they are bound. Now, the introduction of digital technologies, they help in terms of processing and monitoring that data that is found. This then helps in terms of improving and strategizing. Now let's go to the last aspect of it in terms of opportunities to employers. Now the collection of data and conducting surveillance is much easier than it was before. Such that in the olden days you needed to have a supervisor to monitor a worker if the worker is doing his or her job. But you can have this monitoring and checking technological devices that can help in terms of gathering that particular data. Again, it helps in the sense that in the olden days where we used paper you needed to have bookshelves, libraries, and other storage facilities, which were additional costs to employers. But now with digital technologies, you are able to save on iCloud, you are able to save. Even if you want access to information, you can get it on your computer without having to go to the particular workplace. Now, you are able to get information in a sense that the digital technologies, we are able to access information by just referencing, cross-referencing. It takes you to this desired information or data that you want. Unlike in the olden days where you needed a librarian or a bookkeeper to go look at the different shelves. Now the last part of it before we go to worker is that, like I mentioned earlier, it included a lot of people, a lot of supervisors, but now you can just in your computer. Now this then helps employers to improve their existing models, particularly on productivity and effectiveness of its strategies. Those are amongst the opportunities that this then presents. Let's go to the employees. The employees are affected in many ways, but I would mention just three. The first one is a threat to privacy. That the use of digital technologies poses a threat to their right to privacy. And the right to privacy is referred to as the right and reasonable expectation that employees should at all times have some degree of intimacy, independence, and secrecy. Now, if you check the African Charter on Human Rights, and you also look at many constitutions in South Africa, they prioritize and protect this fundamental human right, the right to privacy. Now, the introduction of these monitoring and surveillance devices in the workplace, they possess that threat to violate such a very important right. Again, with some softwares, monitoring and surveillance softwares, are not that advanced such that it leaves or exposes employees or workers to criminals like cyber attackers and hackers. Another thing that we found in this paper was that the threat to a bargaining strength of the workers is threatened if, as a worker, you know that your employer knows too much about yourself. Your bargaining power is at least weakened in this context. Now, there are other issues that digital technologies have in the workplace, particularly on the side of workers. There is internet connectivity and affordability. If you check across South Africa, there is an issue of network signal, network coverage, particularly in the rural areas. The area where I come from, if you want good connection, you have to go uphill. Another thing is that in Africa, data is expensive. Now, those are the two things that are key in terms of the problems that workers would face. Another thing is that because the introduction of digital technologies means that you can work from home now. But if you look at the statistics, particularly in the case of South Africa, where there is increased reported cases of gender-based violence, workers are exposed to working in a gender-based violence-centered environment. Now that then puts them in a way that they can't be productive. Another issue is that Africa is still a developing country, and the working class does not earn that much, such that some people can't afford big houses. Now, to work from home, there is an issue of space. You have your kids, you have your family, you have your cousins. You can't really be productive in that way. Another issue is that it affects the family structure, it affects even your health, like it has been mentioned earlier, because now there is overload, we are always connected and all of that. Another thing is that employers are taking a direction to abuse this or use it in their favor, in the sense that there is an emergence of a gig economy, and they want to replace part of the workforce with gig economy. Now, with that, we would see salary cuts and wages. Now, and then you have a fear that your employer knows too much, in the sense that some surveillance devices, you don't see or dictate as a worker that you are being watched by your employer, even at your work. And with the lack of legislation in terms of defining the extent to which surveillance and monitoring is allowed, leaves a lot and threatens the right to dignity and freedom of workers. Now, on the other ethical issues that we face is that there is no clear guidelines as to, like the point I just made, to which extent is the employer allowed to monitor. Like an example that we will remember that was made earlier on. If I'm using the company's laptop and I happen to text my girlfriend, would the employer still have access to that, to my private life? And the difference between private information and personal information, the lack of legislation in terms of that part, present an ethical issue. Again, with the information that is obtained, there is no clear policy or legislation in terms of its confidentiality, that if the information is gathered, would it be stored in a right place without being exposed to third parties that may use the very same information to advance criminality towards workers. Now, another issue is the accuracy of this data that is collected, because it's the employer that has the access to this monitoring and surveillance. And it's the employer only, without the trade unions, that can tell that this data was collected. So the accuracy of it leaves or exposes workers to being targeted by the employers to advance whatever that they want to advance. So evident from this is that the introduction of digital technologies presents a very sharp knife in the neck of employees' rights and freedoms. Now, and then out of this paper, we then found this following recommendations, that there has to be a clear policy position and legislation that states the extent to which surveillance and monitoring is to be used without violating workers' rights. Another recommendation is that there has to be an introduction of mechanisms that protect employees' information from cyber hackers, your advanced anti-attack softwares and all of that. But it must be so at the expense of the employer, not the employee. Now, we need to have a guideline that establishes a monitoring committee that will have employer representative, employees representative, so that the data that is collected and monitoring, it can be evaluated and we can all be sure at the correctness and truth of it. Then we introduce that the monitoring and surveillance must be done in good faith, and it must be purpose specific. It must be to check if the work is done. Also, the data that is collected must always be accurate, and that the processing of data must be fair and lawful. And another thing that the employer must do is that they must empower workers and reskill workers so that they embrace this hybrid, new hybrid workplace. We can then from here conclude that like it has been said, the technological devices give a threat to workers. That the right is directed to human right to freedom. But again, there has a need to formulate policies, legislation, and clear guidelines on how to integrate, and that there is a need to embrace digitalization in the new paradigm shift in the workplace by both employer and employer. The future of work is hybrid. Thank you.
Should it work? No, thanks a lot. Okay, thank you very much for your nice introduction. I think you clarified very well all the possibilities of digitalization, but at a clear moment, of course, all the risks that are associated with it. Are there any questions you already have in mind? Yes, perhaps you present yourself and then from where you are.
My name is Saki Makumi. I'm more confused at the end, particularly your recommendations. Where is the real threat? Because what we are saying, we say it is good provided it is to the advantage of both the employer and the employees. And those surveillance things that are used, there is a purpose, and the purpose most of the time is they serve as deterrents. And you'll find that the employees themselves will be going into social media, having submitted a sick note, but posting that I was at the gig yesterday. So I get confused in terms of where is the threat. Particularly your recommendations really clearly shows that we need this advancement in technology.
Okay. Now the threat lies with, particularly, we agree that the surveillance and monitoring are necessary for the effectiveness of businesses. We agree that. But where we, in terms of looking at this broader concept, we're looking at a threat to, we must always close spaces where the employer can misuse such digital platforms to them. Now, more so on the right to privacy, we need to have clear policy and guidelines as to if we are talking about surveillance, work-based, it must start here and end there. It must not escape or encroach to the person's life. So that's where I think if we were to improve there, then the whole monitoring and surveillance would work best. So that there is a clear distinction between personal and private information. And more so on the last part is that there has to be some sort of guarantee in terms of guidelines and policies that protects the data that is collected, such that it is not exposed to cyber attacks and all of that.
Thank you for a very insightful presentation, Mr. Mayenzeke. The only part that I'm just thinking about, as we move more towards, towards this digital working remotely and so on, that the tools of trade now are not based in the office; they are in the hands of the employee, and some of the employers, they would tend to even be more abusive in the sense of they can now call you at any time, even off hours. Oh, I need this quickly, I need that. So I think the legislative part of it, the policy aspect should kick in, although I don't know the practicality of it, because as an employee, you don't want to be seen to be uncooperative because you are at home. So I just want to get your views about that. Thanks.
Oh, yeah, I think I share the same sentiment that, like it has been mentioned by the other speakers, that this change in the workplace, the change of model, presents an opportunity that even at 8 in the afternoon you'll be requested to be connected, you'll be requested to do something even on weekends. And more so, if we were to look at that, we need to even include overtime remuneration for that. Because you'll find in most cases, but then this then clashes with what? It then clashes if my work, I'm going to do my work at 8 and end at 4, I'm paid for that. But because I'm home, I'm working at home, I get to finish it at 12. Then I would leave. Now is that at my advantage? Now when the employer monitors, the employer would see that I left work at 12. But I was done with my work. Now it then clashes with, if the employer now wants a favor, it's after 4, wants to connect for 30 minutes to sort something. I think we need to have a balance and be sort of tactical, flexible in that extent. But at the very same time, if these hours exceed a certain amount of hours, it should qualify as overtime.
Thank you, Mr. Chair. I just want clarity, or if you can expand on the threat to the employees' bargaining power that can be posed by the employer's access to employees through technology. What does that mean? What threat would that be?
Okay. Now the threat is that with unregulated monitoring and surveillance, the employer is able to get information or data that at some extent might put you, or let's say for an example, you were always connected, the employer's computer or the works, then maybe you go to a certain site by mistake. The surveillance and monitoring would require that this employer at 1 o'clock viewed a pornography site. Now that gives the employer the right to actually threaten you when in the bargaining process, when they are clashed with you. Unlike, then the other example that in expanding this is that with the information that the employer has, that the employer can collect without any limitations, presents a bigger opportunity to employer of knowing too much and actually using that to either threaten you or influence your decision or your bargaining, your views in the bargaining process. It's in that context. Because they would know what you were doing, they would know about your family, they would know about this and this, and they would know about your ways. Then when we are clashing in terms of the bargaining council, they can try and influence that, which is outside the scope of employment, but it poses that threat.
Yeah, I think it works.
Yes, I'm going to follow up with my question. I just wanted to engage you on the last question you addressed. I would think that the threat would be more a numerical threat. The bargaining power would be the strength in numbers that digitalization has as a sine qua non, that the obsolescence of jobs and the power lies in the masses. And I think we have more of an existential threat. I see the workers' right that you're citing, but you need workers to exercise their rights. Yeah. And in asking a question to you, hope I'm not being unfair, to be clear, where do you see labor bargaining in 20 years' time, given the dwindling of jobs that are just a consequence of AI? Are we having unions going to be something of a past, or are we going to have them? And if we do have them, what extent are we going to actually have them? I think that's what we want to know as a takeaway, especially I as a industrial practitioner, as an attorney, representing some of the trade unions. Am I going to have clients 20 years down the line? Because the extension proves that we can't compete with AI, and the most certain fields already have been overtaken by AI. So when we look at the rights, that's one thing. But how are we going to have workers competing with this machinery?
Can I just, before you answer, because we have several questions. First, let's put them together, then we can see if they go in the same lines.
Okay, no problem.
Yeah.
All right. Thanks, Chair, for your presentation. Mine are more of comments in relation to what you presented. We are aware that the train has left the station in terms of 4IR, be it in the public or in the private sector. But I think the most important element would be what form of policies are going to be put in place to ensure that there is employer rights, and as well there is no job losses with the introduction of digitalization in the workplace. How do we balance that element? But at the same time, you have spoken around the monitoring part of saying if someone is working, let's say work from home or remote working as it is being called, there is need for somebody to be monitored. I think it goes back to the element of building trust between the employer and, because remember it's a relationship. How do you build that relationship to ensure that there's accountability and trust? You don't monitor me because I'm working from home, but you know that I am accountable. And given the issue of working hours vis-a-vis tasks is something that could be discussed as well in policies to say, are you going to look at me according to the hours I've worked, or because of the tasks you want me to complete, be it in a day or in a week? So those are the changes that need to be looked into if you are looking into the future of the workplace.
Wait a moment. So many people.
Okay.
You wanted to have. You see if they can be interrelated.
Thank you very much for the presentation. But my view is that we are seeing and beginning to fear something that is not there. Because the presentation and the debate seems to gravitate towards a situation where the employer has no interest in advancing and innovating his or her business, but is more interested in monitoring and pursuing employee privacy. I don't know at what cost, whether the employer would really have the capacity to do that. First, in most instances, the employer has your personal details, not necessarily private. But with time and the advent of a number of certain medical conditions, where now the employer has a health risk, a manager in the workplace, and sometimes at the employer's cost, certain employees will have to go through these processes in order for the employer to determine whether or not this employee is still fit for purpose. In any event, the employer access that kind of personal, sometimes private information. So I'm not worried. What I hope to be getting from this presentation, following from my colleague, is the threat that is facing trade unions, that this digitalization is threatening the trade unions in the current form and the current approach. Therefore, it calls upon now on trade unions to adapt. And one of the options is to consider whether militancy is still the instrument, or being smart is now the new tactic, so that they can even lead policies to say, because of the following, in order to protect the privacy rights of our employees, please let's engage on a policy like this, let's engage on a policy like this, let's engage on a policy like this, being fought by the material conditions of that employee on the ground. Thank you.
Okay, we have one more. questions here?
Thank you. I think the first one is a comment that I have. People are panicking over something that is already happening, which is going through employees' private information. All you need to do is to be IT smart and go to the backside of the server and see what the employer sees. All the traffic that goes through the employer server, the employer sees it. And in most cases, we're using the employer's time, the employer's laptop, and everything to actually transact personal business during working hours. The employers just keep quiet because it's one of the hazards of doing business. So they already know that. Then my question is, we need obviously a clear take home from here. It's easy to say policies can be made, that can be driven by boards. It's easy to say systems can be put in place, that can be driven by organization. But to go as far as legislation, the question arises, who is going to bail the cats? If you look at most African governments, it takes a minimum of 18 months not to put an act into operation, but simple regulations. So, and the world of technology is moving very, very fast. So the big question we should be taking from here is, yes, we can have a talk show every 2 years, we come here and talk. As long as we don't engage government, the governments do have their systems to work faster and actually embrace these technological issues and transform into legislation. We would then have to sit and rely on courts to actually set those precedents as we walk along, which usually is problematic. You are better off sitting with legislation. So the question is, how do we bail the cat so that it doesn't take too long to make the legislation?
Okay, may I just, and then, because I'm looking also to Claire, and I think we have 4 minutes to close, or 5 minutes. Can I just add one issue to the debate, because it's interesting. Now you speak, of course, a lot, we all agree that digitalization helps a lot and that there are certain risks. On the other hand, you speak about the right to privacy. Let me put now the other way around, the risk for the employee. But is there also not a risk for the employer on the other side? I'll just give you 2 examples we have. In Belgium, we had a big discussion going on that until now, for example, if you were sick, you had to go, you have to declare it to your employer, and then you have to demonstrate, basically you have to go to a doctor and bring in the form. Today they decided, no, it's sufficient that you enter into the app that you're sick and you don't need this form anymore. You don't have to go to the doctor because they found it ridiculous and it's a lot of work on that. So you can do that. The reaction from a lot of employers is, yeah, I mean, have to trust the employee that he or she is really sick, of course, on an end as well. And put it the other way, you just said, like, if I'm surfing on certain websites, that would be presumably during my business, and on websites I cannot see, and I should not be allowed to see whatever on that matter. But what we also see that certain employers now basically starts like, well, it's impossible to download on your computer, for example, even to go on Google, excluded to go on that because they say, well, don't I have the right to control sometimes if people are working and really on that? I mean, these are reactions. Perhaps you can combine it in 5 minutes, all the questions would be lovely. Thanks.
Okay, thank you very much for the comments that have been made and the contributions, because some were really contributions that in the next paper I should improve this and this. With regards to the first question, I think there is a paper I presented a webinar on in December that spoke about the digitalized collective bargaining. And the thread or the conclusion from it is that there is a deliberate weakening of trade unions. That the introduction, in the context of collective bargaining, the introduction of digital technologies sort of shifts power to the employer. A very small example is that during COVID-19, not all trade unions have the financial muscle as the employer, such that in some cases, for you to join a meeting digitally, you needed connection from the employer. Secondly, the organizing those bargaining meetings, at times they were the employer initiated that. And when that employer initiates or organizes this Zoom and there is this heated argument, he can mute you, unmute you, kick you, and all of that. These are the other aspect of it is that there is data connectivity, affordability, and space that is also needed. But to sum up the whole problem and to try and answer, I think 20 years down the line, the trade unions will be more weaker than they already are in Africa. There is an example, if you look at the Labor Relations Act, because employers are now exploiting this. If you go to the Labor Relations Act, you could be retrenched for operational requirements. And that posed a threat to workers and trade unions. Because as an employer, I could just declare that financially I'm in trouble. But yet in the previous years, I was making a lot of profit. But for this year alone, I would declare that I'm making losses, therefore I'm retrenching on operational requirements. That gave the power to employers and shifted the power from that needed, in terms of case laws, to be regulated, to at least try and have a balance. That we need to evaluate, if you are saying on operational requirements, we need to evaluate your finances and arrive at that decision. But you see that at first it presented an opportunity to be exploited by employers, just like digitalization. And I think we need to re-strategize as the left or trade unions. They need to re-strategize and try to find balance. And I agree with the second speaker that there has to be trust. There is no need to monitor. Maybe what can be done is that we agree with the employer that on weekly or quarterly basis there are reports, and in these reports you would see progress and you would see that work is being done. Another one on the, I agree with you that even employers, there are risks such that there are many people connected to the network or the safer that actually gives a chance for cyber attacks. And another thing is that where do we start? I think we can start as trade unions and workers to initiate and policies, because I agree with you. If we were to wait for government, it would take forever. They take time to even initiate a bill. So I think we can start at the ground, try and formulate work-based policies and try. But the employer might be resistant and the workers were, but the long and short of it is that we need to formulate work-based policies that would relook at this modernized work environment and see if we can work. And the other one, I think I've covered, I think, but if I don't cover, we can just on the sidelines, we can talk about it. But I can also share that paper on my presentation that I did on the effect of digitalization in the collective bargaining. Yes.
Okay, so it's on the African labor law side. I think this is the best conclusion, that we can share your text. Many thanks for your introduction, your wonderful thoughts, and a lot of discussion. I think we learned that we have another topic for the 6th African conference on a certain issue. We already have a topic now, it's the place that we have to decide, but that's another issue. So I thank you very much, and this is something we always keep rounding up. So welcome again after the coffee break. There are 2 more sessions going ahead. The one is on, I have to admit, from a European perspective, hot topic. The impact of environmental, social and corporate governance in the workplace, how are going companies and an organization to manage risks and opportunities around sustainability and embrace the principle of, I would say, fundamental rights and sound governance, which is a clear legal issue. ESG is booming. So I'm very happy that we have also from an African point of view. I don't know if I need, but I will of course present to you our speaker, Mr. Georgina Ogalo. I mean, if you have been last at a previous conference in Nairobi, then you would definitely have already have met her. That is immediately implying that I was there. So on that, she's a senior legal counsel, very much involved in business and labor, the connection between it, or the conflict between it. Perhaps at Airtel Africa in Kenya, and also fresh member of the management board. Yes. So great. Georgina, I give you with pleasure the floor.
Thank you very much. As you have said, yes, my name is Georgina Ogalo. And I am presenting the paper today, the impact of ESG, which is, I would say, the new buzzword, the new sustainability, the new strategy that a lot of businesses are now taking up. And what does that mean for Africa? I'll be looking at the what, the why, and the how, because it is really a new concept, especially in Africa, in terms of using the terminology ESG. To be very honest, ESG has been with us from as early as literally mankind. It looks at how are we going to sustain our current environment, how are we going to sustain our community, how are we going to sustain interactions that we have, especially from a business perspective. And this sustainability all comes down to what are we creating today that is going to grow businesses and grow our global effect as a community for the future generations to come. When I say ESG has been with us, a lot of organizations had already been doing corporate social responsibility. When we put all the employees together and they go out and do community services and activities out, in terms of into the community, bringing out what the business does, but also supporting the communities around them. It also referred to what were we doing internally as a business. What was the right thing that we're doing from a governance perspective, and what was the right thing that we were doing for employees. And based on this, the sustainability element in terms of definition came out from the United Nations, where sustainability looked at meeting the needs of the present without compromising the ability of future generations to meet their own needs. And that's what the key word sustainability comes from. And out of looking at sustainability, it has an interplay of the disciplinary elements of environment, social, and governance. So at the end of this 20 minutes, the one thing that coming out of this you should really focus on is those three elements. We're already doing them, but now we're defining them. We're making them part and parcel of our businesses and how we do work, both in the private sector and public sector. And I'm going to break it down from a practical perspective. To be honest, for me, ESG came alive in the past year within my organization. I had been hearing it, as I said, as a buzzword from America and Europe, but now it's becoming ingrained in Africa. Why? We've got a lot of investors and multinationals within our markets. We've also got businesses that are growing. They are growing, and the expectation, not just for investors, but also for customers and your employees, is that you do better. And how do we do better? How are we affecting our environment? How are we affecting the way our employees are treated? How we treat people internally? How are we affecting the way we treat people externally? How are we giving back to the community? And ultimately, are we doing the right things in terms of managing our businesses? When we say we have a code of conduct, when we say we have a right way of doing things, are we doing it the right way? Are we just ticking boxes? So I wanted to come out from more a practical perspective rather than just what needs to be done and said. Why the word ESG? Initially it was supposed to be GES, governance first, but I think within the interplay of a lot of elements, environment came in the forefront. From an African perspective, there are a lot of things that I would say, even in my own home, growing up, we did from an environmental perspective. I don't think there's any African child who doesn't have in their kitchen a plastic paper bag with many other plastic paper bags inside them. We never threw them away. you just reuse them. They'll be used as bin liners, they'll be used in the market again, and that's just the element of recycling. No one had to tell you. It was just because let's not be wasteful. Can we reuse it? I don't think there's any home in Africa the tap just ran, because most times there was no tap. And if there was a tap, you use it and you close it. And then that is one of the concepts that for when you come and explain ESG for us, we're already doing it. We've been doing it. How are we just going to make it better? Another element in terms of bringing it closer from an environmental perspective is we're now going into an age of paperless. COVID made us do that. You go into businesses and there'll be tons and tons of paper. During the COVID period, I transitioned from a law firm where I was seeing papers literally every single day to in-house counsel, where right now, I can't remember the last time I actually printed anything in the past 6 months. Everything is online, we have clouds, we send emails, my desk is clear. And that's not just in-house, that is also in law firms. You're now filing papers through registries online. That is part of it. So I'm just showing you what we're practically doing, even from ESG, from the judiciary's perspective, from law firms' perspectives, from other businesses and otherwise. Now, within the definition of ESG, it's basically a framework that helps stakeholders understand how the organization manages its risks and opportunities around sustainable issues. Why is it big, especially for our organization? So for certain companies, there's a regulatory requirement for you to have a sustainability policy or strategy. For other organizations, they just want to do it the right way. Other organizations want to be more attractive to investors. A lot of investors will come and ask you, okay, the financials look good, but what else are you doing in the world? What is your business doing other than just creating profits? What are you doing also for your employees other than just paying them their salaries? Are you training them? Are you creating promotion opportunities with a diverse perspective of things? Are you looking at inclusion? Are you looking at protecting your employees from harassment and bullying? Those are the big pictures. And it's not just even investors, it's even customers. We've got a very big growth in terms of social media. One wrong move and a customer is already complaining about you either on Facebook, Instagram, or Twitter. And that hurts your reputation. That is a risk to your business. So all of these stakeholders together are important for you as a business. How are we perceived and how are we doing the right thing at the right time and creating strategies within the organization for that. And the general move is have it very clear, but make it very simple. I'm not an ESG expert. I'm just somebody who, over the past year or so, has had to practice in that area as a lawyer. Legal is always the last one that they come to. It's usually about the contracting or somebody has done something, how do we now start managing the exit process? But before we even do that and get to the point that we're managing an exit process or we're managing a disciplinary process, what policies do we have in place as an organization for that? And that's where I come in. Also from a perspective as a business, our boards, our governance, our code of conduct, what are they reviewed for from a legal perspective? And that came up a lot. So that made me have to understand what are our obligations internally and also externally. And the benefit is that my organization was also moving into a phase where they wanted to have a very robust sustainability reporting and process management. And we played a very big part on that, especially on the social and governance perspective. So I'll just break down right now what those elements of ESG are. So oh gosh, I thought my whole presentation had gone down. Sorry. So the first element is the environmental. And as I had already stated, environmental basically looks at the elements that are around us. It considers how a company measures its impact in the natural environment and natural environment's impact on the company. For instance, in terms of physical climate risks, what are we doing in terms of making our environment a better place? There are various activities that we undertake. Elements of looking at climate change. What are we doing as organizations with respect to carbon emissions? Very big in, I would say, first world countries, but also very close to home. We have the benefit in Africa that we've got, I think, the largest range of rainforests and vegetation and animals in the world. But that can just go away in a blink of an eye. we can become a concrete jungle. What are we doing to protect that? We are literally under siege. We've got a beauty within most of the countries we live in, but we just don't understand that. What are we doing in terms of recycling? What are we doing as a business in terms of, as I gave an example, in terms of wastage policies? As a tech company where I work, we're churning out and using like elements like laptops. When they become obsolete, are we just dumping them at IT and then they dump them into another refuse and then it just becomes garbage and more garbage in terms from a technology perspective? How else can we recycle? Those are some of the elements from an environmental perspective that we can do as a business. And that comes into also sustainability investments. As a business, how much money are you putting in to ensure that you're reducing how much you put out there in terms of hurting the environment? Renewable energy, green building. The offices that we go into, in some of the countries that we live in, it's very hot. Are we just going into the offices where everybody has an AC? Every single office, on average, 50 offices, everybody has air conditioning. Are we looking for offices that have better lighting, more windows, natural ventilation? Those are some of the things as a business you look at instead of looking at wastage, which is really up there. Africa right now, and I think also globally, fuel is a problem. The cost is high. What are we doing as an alternative form of energy? Are we looking at cutting down our lights in some of our offices? And then what alternatives do we have? Are we looking at solar options? Those are some of the things as a business from an environmental perspective that should be looked at within your strategy. And then also, as I gave the example, going paperless. We're coming back for deforestation. Must we cut down on so many trees? Can we cut down on our paper usage? We're now going digital. Let's make those moves and strides within our different businesses. And from the environmental perspective, it just looks at how is your company treating the environment. From a social perspective, as I said, social really hits hard, especially with respect to employees and employers and the business, the heart of the business, which is the resources. As we're resourcing, are we looking for that diversity element? I remember when I was interviewing to our current company, which is a very male-dominated industry. I sat in a panel of 5 men. And at the end of the interview, they asked me, do you have a question? Like, will I be reporting to a woman? And it was very intentional. And I think they said there was a response, a very political response that was given. But I remember the next stage of interviews, the HR director who had already interviewed me came back and explained what our diversity policy is. But even coming into the organization, I have seen them strive to create that diversity. But one key thing in terms of that creation of that diversity, we're not slacking on quality. You don't get that position because of your gender, because of your race, but it's because of you're good at what you do. And we're giving you an opportunity to do that, and that has been emphasized. So what are you doing in your organizations for that? So that covers diversity, inclusion. There's also the human rights element. A lot of us just tick that box because that's what the law says. To be honest, just do the right thing. Human rights is just as a general right in terms of how you treat a person. And that trickles down in terms of what the heart of your organization is and what your culture is. Don't be caught on the wrong side of that. It's both a risk from a litigious perspective, monetary perspective, and a reputation. But it doesn't matter what amount of money, you can't bring back a reputation that's lost just because you're not doing the right thing. Another element is, of course, labor practices, which have also been covered quite extensively today. What are you doing to adhere to these labor practices? Are you a company that constantly, you're being reported to the labor office? You're always going into negotiations all the time. Why can't you be the company that proactively, ahead of any complaints, ahead of any regressive elements against you, come up and put up good policies for your organization? Be that kind of company. Then there's the element of anti-discrimination, harassment, and bullying. How do you deal with it? Do we all just sweep it under the carpet, pretend it's not there, or we just try and silence the complainant? How are we managing it? Right now, legislation is very clear that you have to have policies with respect to harassment. Have those policies there and also implement them. and also protect those who are in those situations. Then also this has also been dealt in the two previous presentations, the element of privacy and data security. What are we doing with our employees' data? Are we just collecting it? And I think the example this morning was when we're done with it, we just trash it and then somebody finds it being used to wrap meat or chips the next time when they go to a kiosk? Or are we treating that information and data properly? And then when we do have that information, how are we also disseminating it? So those are some of the elements from a social perspective. And then there's also health and safety. How are we treating our employees? Are we taking care of them? Are they sitting in nice ergonomic chairs? Are their postures right? Do they have the right laptops? Are they fit for service, fit for work in terms of the resources that we have? Then comes the governance part. So this for me, the last social and governance are very close to my heart, especially governance. From a company secretarial and governance perspective, it's very key. From compliance, regulatory perspective, these are the things that we must uphold. When the board comes and says, as a company, this is what we're doing, this is what we're pushing, these are our policies, it actually has to mean that, and nothing less. For directors on boards, your liabilities is just stronger than just what you have a seat on the table. What you push out as policies, what you put out in your memos, what you put out in your annual statements and reports actually have to mean something. And mean something to the business and also the community out there. When you say that you have a code of conduct, when you say you have policies and procedures, make sure those are adhered to. And that, in essence, for a company is ESG. Without getting complicated, without getting into what am I going to do from a strategy, if you understand these three elements, I'm sure most of you already are doing them, and if you aren't, your takeaway from this is start. Why is ESG important? I already mentioned that a lot of investors now are not just asking, is your business profitable? What is your business giving back to the community and society at large? So that's a key element. Your consumers, they want more. They want you to be out in the community with those large profits in terms of building things around you. As much as you're making money from these consumers, they also want to see being plowed back in your respective economies and at large. From a legislative perspective, also, there are countries where, from a legal perspective, you must have an ESG strategy or sustainability reporting. Mostly America-listed companies, US Securities and Exchange Commission requires of that. There's also global reporting initiatives, I know in the United Kingdom and some European countries. And by extension, a lot of the multinational companies in Africa also have that requirement. So it's getting closer to home. So we're already doing it, but now put it down on paper properly in a strategy that people can understand and disseminate across the business. Then there's also case law in terms of litigation. Why do we have to have suits with respect to climate matters, risks, also from a human perspective, labor practices, all that fall under that risk of litigation. Corporate regulators, also some of them require ESG policies and strategies, so you see coming up a bit. And then also companies. As directors also get a better understanding of ESG requirements, they'll be asking this for a lot of companies. Because they stretch out and operate in quite a number of these industries, and they know what needs to be done. Now, having given an overview of what ESG is, what is it as an impact to the workplace? As I said, for the workplace, a healthy environment means also a healthy work environment for both yourself and externally. It's also great when you have employees who have a shared value in terms of what you're doing with the environment. If you're all on board on that, it's very easy to move to paperless. It's very easy to move initiatives in terms of tree planting. It's very easy to explain carbon emissions. So it's quite attractive also. And then if you're doing the right thing will come to you. And that's the right employees. From a social perspective for employees within the workplace, it creates positive employee engagement. Because they know that the company is putting into place policies that are good for them, that are making them more productive. It also motivates employees and reduces turnover. If you're just a business for profit, that's all you're ever going to get, profit. Nothing more. There'll be no growth. It will just be profit. Then from a governance perspective, It also having the policies, a code of conduct in place, gives that, I would say, confidence in the employees that the right thing is going to be done if a wrong thing happens. It brings an element of commitment and loyalty. It reduces any financial and reputational losses, because as a business, when the wrong thing is done, then we have a management structure for it. Either disciplinary process, risk management, those are in place. If everything is just helter-skelter, it's just really going to be a mess in terms of cover-up, and then ultimately the lawyers externally are going to have a really great time trying to fix the wrongs and also meet their targets. Let's try and also keep this internal, sort your things out right now. And then risks associated to unethical behaviors are also sorted out, and that's from the policies. So ultimately, from a really strict workplace perspective, ESG for employees, attractive employee because you're an attractive business. You put it out there in terms of what you're doing from the three elements: environment, social, and governance. You're not going to have high turnovers because people want to come to work. They actually enjoy coming to work because you've created a comfortable work environment and you're enhancing it. You're also looking at a healthy workforce. You're not going to be looking at situations where people are constantly sick, constantly depressed, don't want to come in and are unproductive because you've created a very hostile, unhealthy work environment. You're also looking at more productive, motivated employees. This is where people want to work. But the reality is that no business is perfect. But this is what we're working to. And the minute as a business you come out and say we have a sustainability project and strategy, you actually are put to task on it very heavily. So sit back as organizations, come back and see what can we do better, and let's start from the basics and enhance that. And you have the right people on board with you. And there are also experts out there who can support that. For me, just in terms of example to close over, currently as Airtel Africa, we have a sustainability report and strategy which is online. Our key main pillars right now are our support to our business, community, customers, and the environment. One of our biggest projects right now is that we have a 5-year project with UNICEF, which is on the education, in terms of bringing education closer to every child in Africa, use of technology for that. And it's not just a CSR project. It's close to the heart of all the employees in Airtel Africa because we have to make it work. We're not just investing our money, we're actually investing our time, our expertise, and our resources to make sure that we can cover as many schools in Africa as possible and also bring a new crop or generation of intelligent, wonderful children into the workforce. And that's just one of the things that we're doing. Internally, we have a very big job to play in terms of diversity, but that is going on. And then as a business, it's a day at a time. Those are some of the initiatives that we're working to. And for our customers, we're trying to bring communication closer. So that's it from me with respect to ESG and the workplace.
Okay. All right, thank you very much, Georgina. We have about 5 to 10 minutes for a few questions. I don't know if there are any issues already out of the room. If not, I will post you later on then to get it done. I know. Yes, please.
Good afternoon. My name is Faith Banks. I work with DNS Africa. Thank you, Georgina.
It doesn't work, no? No. Oh, the guy is. Or is the other one?
Yeah. Can you hear me?
Yeah, I think you're loud enough, Faith.
So thank you, Georgina, for speaking on a very topical subject. I think ESG is now becoming more than just a buzzword.
Yes.
I wanted to make an addition. I know that your presentation was focused on ESG in the workplace. And that was really what the topic was, but I wanted to make an addition that what we're seeing out there in the market is that there's a lot of focus as well on ESG throughout the supply chain. So as a corporate, as an entity, as an employer, you could get ESG right in the core corners of the organization. But when you're looking at ESG, you also need to go down the entire supply chain from where you're sourcing from and who you're selling to, so that you get it all right within. But then somewhere down the line, you want is that you've been sourcing your bean chips, for example,
Yes.
from an ethical company that uses child labor, then it impacts your reputation, it impacts your workforce, it impacts your bottom line. So I just wanted to add that, that outside organization model that it sort of looks externally more as well than just internally. But thank you, Georgina, very much.
Yeah, very right, Faith, on that. So, looking at the three elements of ESG, even for supply chain in every function within the organization, you're looking at, from an environmental perspective, the vendors that we are bringing on board. Are they doing or providing us with a service that is environmentally safe? From a social perspective, are we sourcing from a vendor who is contravening labor practices? Are we sourcing from a vendor that has harassment and also human rights violations? Are we sourcing from a vendor that doesn't adhere to data privacy? Then from a governance perspective, do we have the right processes in terms of sourcing? Was there any form of corruption in that process of sourcing for that vendor? So, and there's been pushback in sense when a lot of organizations have anti-corruption and anti-bribery policies. When you're coming to contract with them, they make you comply with those policies. And a lot of people say, oh, we already have our policies. But no, when you're coming on board with us, you need to understand these are what our bare minimums are. Because from a reporting perspective and regulatory perspective, we also have obligations based on also what you do. We've seen a lot of cases in Europe where companies that came and invested in Africa, where even politicians were found in Africa to have either bribed some of these companies. The companies in their home countries are the ones that are fined, and yet in Africa nothing happens to even some of these members. So it has a larger effect from just a transactional perspective.
Okay, thank you. I know there's one question there, and then we'll be going more. Yes.
Barbara Surdykowska from Poland. Thank you for this very clear presentation, but somehow I find this picture a little bit too rosy. Would you be so kind and elaborate a little bit on the obstacles where you see this process which are stopping the company from this kind of policy?
Okay.
To be a little bit more balanced.
Okay, so obstacles is also the mentality. If people don't understand what ESG is, it's going to be very hard to push that strategy across the business. You need to come from them in terms of what each of these buckets means and where they apply in each of them. And when I say the company, I mean all the employees, the directors, the managers, even the board needs to understand why do we need a sustainability policy, why are we doing it? Then Faith's an example, even vendors and people that you're contracting with, they don't understand this concept of ESG. Bringing them on board. It's not enough to just throw policies and contracts at vendors and say you must comply. Because they can sign it off, but they're actually doing contrary to what you're saying or doing. Another element is that it is foreign. Even as I was doing my research, a lot of the examples were mostly from Europe and America and Australia. There is a lot of literature in those regions. Within Africa, South Africa, in terms of even rating, is quite high in terms of their ESG sustainability, reporting and strategy. But for a lot of other African countries, this is a very new concept. So getting it across, I would say another 5 to 10 years. But it's not we're not doing it. We've been doing it for over more than 100 years. I gave simple examples even from an environmental perspective, why it's already being done. Another thing also in Africa, environment is important to us, but because we see it. We see trees, we see animals. We are now getting the effect of climate change now, but if you ask some of the countries, do you know the carbon emissions in South Africa right now, what the rates are? Most don't. I don't even know in my own country, because it's not a real element right now. So it's going to take some time, because it's come from another continent, another country, and we now have to synthesize it. I am only doing it because as a company, we are global, so we have to have that global reporting, global strategy, and we have to pass it down to our different operations. And that's what we're doing, going down.
Can I just we have to stop more or less. Because I think there is we have one more question, perhaps?
It's just, I'll be brief, so this out from Denton's, just to add to this. To be honest, there's a lot of financial impact to trying to implement this. It can be easier for multinationals, but less easy for small economic companies, for example, because let's face it, putting a recycling program or even contracting out to a recycling company can be costly. So unfortunately, I understand there is a price to pay. I also understand how important it is, but there is a whole balancing exercise that has to come from an economic point of view as well. And at the same time, we understand the second that Europe have got guidelines and laws. Unfortunately, I do feel that unless and until specific reporting obligations don't come in Africa, I'm not sure how much everyone.
It's still going to take some time because, as I said right now, even from a legislative perspective, the US, for some listed companies on the securities exchange, even in the United Kingdom, not every company has to have a strategy, a sustainability strategy. What they're currently trying to do is a uniform framework for sustainability reporting, but not a compulsion in terms of having a sustainability report.
Yeah, and even before you started, there's greenwashing claims that have started because unfortunately people just aren't implementing the right way.
Okay, I think we more or less have to stop because we're going to a last. We're going to a last session. So I would like to thank you. If I may just make one reflection.
Yes.
We are speaking about Europe and there is a lot of ESG. The fact is, for us, many of us consider those as window dressing. Basically, like companies have a strategy, but the people in the street or the clients are not following it. Basically, I just give an example. All our consultancy firms make the most beautiful ESG strategies. The question is, are you going to choose that or that one because they say it or they do it? And that's an issue that pops up regularly in our country. So I would like to thank you.
Okay, so welcome once again, everyone. We are going to be hearing from Dr. Cecile de Villiers. Is that correct? Okay. And she is going to be discussing the increased use of digital arbitration, South African insights from the public basic education sector. As you can see here from her presentation, I'm just going to introduce Dr. de Villiers. She is a postdoctorate research fellow in law at Stellenbosch University, specializing in labor and education law. She's admitted to the bar as an attorney and also a published academic author and has been featured for her research in a number of media interviews. Dr. de Villiers is part of the Court Quote This Woman and database of experts. And with that, I will turn it over to you to begin your presentation. Thank you, Doctor.
Thank you, and thank you so much for everyone for being here. I am fully aware that we all want to get to the cocktail function, so I'm going to try and keep this as brief as possible, and I hope that this is something that is interesting to you and that you can take something away from this presentation. So the presentation focuses on the experience with digital arbitration in the public basic education sector in South Africa, and more specifically on misconduct arbitrations involving sexual misconduct perpetrated by educators toward learners. So I'm going to start with a brief overview of the legal framework and firstly just telling you what the basic education sector looks like in South Africa. Then we are going to consider the legal framework facilitating labour arbitration and then certain developments that took place within this legal framework as a result of the COVID-19 pandemic. So the experience with digital arbitration in the education context sets the scene for a discussion about two procedural issues in arbitration, which is experienced in the education context, but are also applicable beyond this specific context. So I will also conclude with a number of challenges faced by digital arbitration and also then the opportunity to address some of these challenges through practical suggestions also from the English and the Canadian experience. So if you have a look at the slide, this graph provides an overview of the basic education sector in South Africa. So basic education refers to school education from grade R, which is the year before school, up until grade 12, which is the final year of school. So the green indicates the number of educators, learners and schools served by the public education sector, and the red, which is barely visible on the slide, indicates the same for the independent sector or the private sector. So what this graph shows is that by far the majority of learners, around 94% of learners in South Africa, are served by the public education sector. And the same goes for the employment of educators. There are around 405,000 educators working in public schools in South Africa, and this translates to 90% of all educators employed in public education, or in basic education rather. So for this reason, the focus is on the employment of educators in public schools and the experience with digital arbitration in this specific context. So before we delve into the issue of digital arbitration, let's first consider the legal framework that facilitates labour arbitration in South Africa. So for those of you who are not familiar with South African labour legislation, the Labour Relations Act governs labour relations in South Africa, and is also the piece of legislation that provides procedures for the resolution of labour disputes. The Commission for Conciliation, Mediation and Arbitration, the CCMA, is the statutory body established to resolve labour disputes in South Africa. So as you can see from this slide, Section 138(1) of this Act provides that a Commissioner may conduct an arbitration in a manner that the Commissioner considers appropriate. So it also provides that two requirements should be met. Firstly, the dispute should be determined fairly and quickly. And secondly, the merits of the dispute should be dealt with, but with the minimum legal formalities. So this section explains what the powers of commissioners are, but it doesn't determine what the format or the mode of proceedings should be. So in this regard, Section 138(2) provides some guidance by providing that the Commissioner has a discretion as to the form of proceedings, provided that procedural fairness is still adhered to. So the parties to the dispute may give their evidence, they may call witnesses, question their witnesses, and also all the witnesses of the other party, and also address concluding arguments to the Commissioner. So if we go back to the two requirements in Section 138(1), the dispute should be determined fairly and quickly, and with the minimum legal formalities, subject then to this elements of procedural fairness that I just mentioned. Then this framework leaves room for a Commissioner to exercise his or her discretion to determine that the arbitration should be conducted virtually. And this could be done via a video conferencing platform such as Zoom. So Zoom is just one of the platforms that are available. Many of you might be rather familiar with MS Teams or Skype. So I should also mention here that the Education Labour Relations Council is the bargaining council with exclusive jurisdiction over labour dispute matters arising from the public basic education sector, where the state, which is then the Department of Education, is the employer. So this council is regulated by its constitution, which contains almost identical provisions to those in the Labour Relations Act that are on the slide. So it also provides the Commissioner with a discretion as to the format of the arbitration hearing and how it should be conducted. So with this legal framework in mind, let's consider the impact of the pandemic on arbitration hearings conducted by the CCMA and by the Education Labour Relations Council. So the pandemic served as the catalyst for trialling digital arbitration, and in May of 2020, an urgent CCMA directive determined that in case of arbitration hearings, the parties had to agree in a pre-arbitration conference as to the location of the hearing, and two options were provided. Firstly, it could be at the employer's premises or a virtual hearing via a video conferencing platform. So the directive incorporated the input of parties, and they were able to provide reasons if they disagreed to having the hearing at the employer's premises or virtually. And similar to the CCMA's approach during the pandemic, the Education Labour Relations Council also shifted to virtual hearings, and it actually amended its constitution in 2021 to include a provision regulating virtual hearings. So this is also an indication and a positive development on the side of the Education Labour Relations Council, showing its willingness to incorporate virtual hearings going forward. So I'm going to skip this part about witness testimony in the education context, but what I just want to mention briefly is there are certain protective measures in the education context because witnesses are often children, and for that reason there are certain accommodations in order for them to provide testimony in camera and also through an intermediary. So one possible critique against the use of digital arbitration is that it is difficult for an arbitrator to assess the reliability and especially the demeanor of a witness over a screen. And this is especially so, as we all know, where there are instances of poor connectivity resulting in a delay in the video stream or poor video quality. So an argument along these lines was made in Campbell Scientific versus Simmers, where the respondent in a sexual harassment claim or sexual harassment case argued that his right to a fair hearing had been prejudiced by the manner in which the witness, who was the victim of the sexual harassment in this case, that he had been prejudiced by the manner in which she gave her testimony at arbitration. So in this case, the commissioner was unable to observe the witness through a video screen, or video stream rather, because only the audio link in a Skype call was operative. So the Labour Court, and this is interesting, was satisfied that even when only the audio link was operative, it was still an acceptable manner for the witness to testify. And the Labour Court in Simmers also indicated that it's not a reviewable irregularity if a commissioner relies on oral evidence of a witness in the context of the limited operationality of video conferencing technology during an arbitration hearing. But ultimately, the commissioner still has to be able to determine what the reliability of the witness is. And a number of practical suggestions from the experience with digital arbitration in Canada have been made to mitigate the potential negative effect of video conferencing platforms on the arbitrator's ability to assess the reliability of witnesses. So the first thing is, and this is a very practical suggestion, is that the video of the person speaking be pinned. So this means that the speaker's video is on the screen and everyone in the hearing is then able to easily identify who is speaking. And then secondly, once a witness starts giving their evidence, the arbitrator should also pin the video of the witness to observe his or her reaction to the questions that are posed to them. So ideally, and if this is at all possible, the arbitrator could also use a large screen to observe the witness. So let's have a look at the experience with digital arbitration in the education context. So what's interesting in this context, and it may be attributed to arbitrators' experience in dealing with child witnesses, is that arbitrators approach proceedings in a flexible manner, and they are also willing to incorporate video conferencing platforms in arbitration hearings. So arbitration hearings in the education context have been conducted in a hybrid format, which involved a combination of in-person and virtual hearings or meetings, and other hearings have been conducted in a fully virtual format. So for example, in the Causa arbitration, the entire process took place via Zoom, and pertaining to the reliability of the learner witness who gave her testimony via Zoom, the arbitrator said that the learner was consistent in her testimony, she did not contradict herself, she came across as a reliable witness, and her emotional testimony seemed genuine. On the other hand, in the Skippers arbitration, which also took place via Zoom, the arbitrator found that the learner witness was not credible or reliable, and this was due to inconsistencies and contradictions in her testimony. So these two arbitrations already reveal that arbitrators are able to determine when a witness is credible and whether the person is not credible. And the Gayaneshwar arbitration used a hybrid format of hearing. So in this case, the 16-year-old learner testified virtually, after which the hearing then reconvened in person, and the arbitrator was also able to assess the demeanor of the witness even where the evidence was given remotely or virtually. So he said that he could see from the video screen that the learner was nervous in giving her evidence, and the hearing was also adjourned for a short period in order for the learner to compose herself, but nevertheless he found that her evidence was clear and consistent and did not give the impression that she was embellishing her evidence. So using a hybrid format of hearing is an interesting possibility beyond the education context, and I will also return to this point a little bit later. So despite having protective measures in the education context, there are a number of logistical issues with these measures. So the Education Labour Relations Council uses the facilities of magistrates' courts or children's courts in order to have special child-friendly venues where learners can give evidence in camera. But the council has expressed concerns that these child-friendly venues are not always readily available. and these venues always or often require of child witnesses to travel. So due to the unavailability of venues, it's sometimes necessary to use more than one venue, especially when the arbitration hearing takes place on more than one day. And courtrooms in this instance may also be an unwelcome setting for young children, which may cause further mental stress and trauma. So digital arbitration could alleviate many of the logistical issues associated with finding suitable venues where child witnesses may give evidence in camera, and providing evidence via video conferencing from a familiar environment, such as a classroom at the learner's school or from home, with an intermediary present, could prevent further mental stress and trauma. So what we see is that the education context already provides for the situation where the witness is removed from the hearing venue to a separate room in order for them to provide evidence in camera, and then that testimony is conveyed through an intermediary. So providing evidence virtually via a video conferencing platform and from a location removed from the venue is not all that different to this scenario. So it was mentioned in the context of labour arbitration in Canada that whether the witness delivers testimony 6 feet from the arbitrator or via satellite makes virtually no difference. So the education context presents the opportunity for the permanent incorporation of digital arbitration, and beyond the education context there are certain benefits to digital arbitration. So I quickly want to mention 2 possible benefits justifying the permanent incorporation of digital arbitration in labour dispute resolution, whether this is by means of a hybrid format or a fully virtual format of proceedings. So firstly, digital arbitration may have an impact on undue requests for postponement. So as we know, the unavailability of representatives and of witnesses often result in the postponement of arbitration hearings. And in cases involving representatives, some of the requests for postponement are for good reason, but unfortunately, some requests for postponement, whether at the disciplinary proceedings or at arbitration, are merely a delay tactic. So whether to grant the request for postponement requires of the presiding officer or of the commissioner to balance the interests of all parties involved. So on the one hand, the CCMA or the bargaining council is tasked with ensuring efficient labour dispute resolution, and undue postponements frustrate this goal. But on the other hand, some cases are more complex than others, and this justifies the involvement of representatives, even though it may lead to proceedings taking longer to finalise. So there are many more, but there are a few arbitrations. I'm only going to mention the first one that illustrate this issue of postponements. So after the educator in the schools matter received notice of the disciplinary hearing, it was postponed 3 times. So on the first scenario, or on the first occasion, the educator's union representative requested the postponement, but on the date that the hearing was postponed to, the educator requested a further postponement since the union representative was absent. On the third date, the educator arrived with a different union representative who requested a further postponement, and the presiding officer agreed to all 3 postponements. So on the 4th agreed date set for hearing, neither the educator nor his union representative was present, and this was more than 2 months after the educator had been served with the notice for the hearing. So a day before this hearing, the union representative emailed the presiding officer indicating that he was not available for the hearing the next day and that the educator was ill. But the medical certificate that was provided in this case was dated before the educator attended the 3rd hearing and where the 3rd postponement was granted. So no mention was made at that stage that the educator was ill. So the presiding officer said that if the educator wanted the postponement, he should attend the hearing and request the postponement, and the educator agreed but never attended the hearing. So the presiding officer then had to weigh up the educator's right to be heard with the rights of learner witnesses who had to make themselves available on 4 different occasions, and the hearing then proceeded in the absence of the educator and his union representative. So I would like to mention 2 insights from these cases, and the Khorisang matters are similar to the schools matters. So the first one is where representatives are unavailable, there seems to be an inflexibility on the side of employees to substitute representatives to avoid postponements. So although an employee is entitled to a representative, and the employee is not entitled to a specific representative. And digital arbitration could go a long way in making arbitration proceedings more efficient, because the representatives will no longer have to travel between venues and often between towns or cities to represent employees. And it may also request undue requests may reduce undue requests for postponement that are aimed at delaying the proceedings, because it will be much easier to schedule a hearing and to determine actual clashes, since scheduled hearing can be available in the same country. And the second insight is the impact of postponements on witnesses. It's time consuming, and it might also have an impact on witnesses mentally and emotionally. So this is especially so in cases involving child witnesses and in sensitive cases where the witness is the victim of misconduct. So reducing the number of postponements by incorporating a video conferencing platform will mitigate the impact on witnesses who no longer have to travel to venues and have to do so multiple times due to postponements. And then the second possibility to testify, or the second positive element to testifying virtually, is that it may increase the participation rate of witnesses. So witnesses are often central to the employer's case who might be unable to discharge the onus of providing or of proving the fairness of the employee's dismissal in absence of witness testimony. But due to the impact of educator misconduct on learners and the potential mental stress and suffering of having to relive the events at the hearing, children are often unwilling to testify. So this may be illustrated by this Van der Merwe matter. So in this case, it did not involve sexual misconduct, but the educator assaulted the learner. So she was charged with slapping a learner, an 8-year-old learner, behind his head, which resulted in him bumping his head against the desk. And the learner, and as well as the other learners who were in the room while this event happened, no longer wanted to testify. So as a result of this, the employer was unable to prove its case, and the dismissal was found to be unfair, and this is then what ultimately happened. The educator, who was a repeat offender for assault, was reinstated. So video conferencing may alleviate many of the difficulties in securing witnesses. As I've mentioned earlier, witnesses, especially in the case of sensitive cases and involving child witnesses, they may then testify from a safe space such as a classroom or a familiar environment, and it also introduces the possibility of incorporating a hybrid format of hearing, where, as was the case in the Guy Nishwa matter, where only the witness, who is a child in the education context, testifies virtually, and then the hearing can also proceed in person. So this hybrid format is also a possibility. So despite the benefits to digital arbitration, to reduce the number of undue postponements and to increase the participation rate of witnesses, the possibility exists that practical challenges will overshadow the benefits of digital arbitration. So effective digital arbitration requires a stable internet connection, access to a device, a video conferencing platform, and assistance with technical difficulties. But the digital divide in South Africa and also in other developing economies directly impacts on the access to these resources. So let's have a look at each of these elements and then possible solutions to these challenges. So in terms of a video conferencing platform, access to that is not a problem, since the CCMA and the Education Labour Relations Council already uses these platforms and will be able to host the hearing with that. It's time to stop. So access to this platform is not problematic. The CCMA and the Education Labour Relations Council already uses it. And the parties to the hearing can merely join the virtual hearing. To reduce, and then I should also mention that commissioners have gained extensive experience with virtual hearings during the pandemic, and in many cases they can provide guidance to parties who experience technical difficulties. But to reduce technical difficulties and also to assist parties who do not have access to a device or to the internet, it is suggested, and this has also been suggested in the Canadian experience, that the employer or the union bear the responsibility to arrange a mobile video conferencing facility. So this sounds very intense, but what it requires is a device, such as a tablet or a smartphone or a laptop, and a modem that allows access to data for internet access. So a further possible solution to the issue of resources, and this is applicable in the education context, is that intermediaries, who are often those used by the Department of Justice, that they be provided with training and a device and a modem at state expense, and that they then travel to child witnesses with this mobile video conferencing facility. So a major disadvantage to digital arbitration, specifically applicable to the South African context, is the intermittent supply of electricity. So a stable internet connection presupposes the supply of electricity, which is currently and for the foreseeable future affected by load shedding in South Africa. So in this regard, it's suggested that a digital arbitration protocol be adopted, and that parties are expected to adhere to the guidelines contained in the protocol. This could include guidance in case of load shedding where parties agree to act in good faith and reconvene at the earliest possible time without load shedding, and also undertake to be flexible in case the hearing has to be postponed multiple times or has to reconvene multiple times due to load shedding. So the pandemic was the catalyst for digital arbitration, and it incorporated video conferencing platforms into labour dispute resolution. The experience with digital arbitration in dismissal disputes in public basic education has been largely successful. And during the post-pandemic period, organisations will either harness the benefits of digital arbitration and pursue it permanently, or revert to in-person arbitration. So it's positive that the Education Labour Relations Council has indicated a willingness to conduct digital arbitration going forward by incorporating a provision to this effect in its constitution. And then just lastly, labour dispute resolution should be accessible, it should be fair, and it should be quick. And digital arbitration embodies each of these principles. It also incorporates further informality and flexibility into the arbitration process. It removes barriers pertaining to schedules and the need to travel, and it's convenient and safe for witness testimony. It also has the potential to contribute to bridging the digital divide by placing a responsibility on the employer to arrange mobile video conferencing facilities for parties, and in this way, access to labour dispute resolution in South Africa is promoted.
All right, how was that? So we do have a few minutes for some questions, and I'm thinking your presentation was so thorough. If you have questions related to arbitration within the education context or arbitration within the context of legal proceedings in South Africa, I imagine that we could explore those as well. So does anyone have any questions? Hands up, I can get the mic to you. Are you ready for the cocktail hour? All right, I see we've got two.
Very good presentation, very clear. First of all, I'm very impressed in terms of the form of arbitration in South Africa with respect to matters coming out of education, because that's a very tricky element in Kenya. Because all those matters end up in the employment court, and it becomes, they said they did, and we never really bring the children into it. It's usually the school, which is usually a public school, represented by the Attorney General's office, and then there's the teacher involved. So it becomes quite emotional and nasty, and especially some of the allegations that are there. Now, bringing in digital into it, if you have one of the witnesses a child, and I'm looking at when we were all during COVID and had online class, and I was sitting with my children, they could barely sit. You'd have to literally, especially those under the age of 6, sit with them for them to understand that we're now in class. How do you bring that seriousness into the whole process? I know you said sometimes it makes it a bit more informal and safer for them, and then not be able to coach them, but to have a 6-year-old sit through an arbitration online and be able to respond without you being, don't put your hand up, don't stand up, and not be considered a coach. How do you deal with such situations?
So the suggestion as a result of this, and especially in cases where the learner or their family isn't familiar with video conferencing, The suggestion is that the intermediary still travel. So a collective agreement was concluded in 2018 by the Education Labour Relations Council, and this has made a massive impact in the case of sexual misconduct arbitrations, because in the case of sexual misconduct, an inquiry by arbitrator is mandatory. So there is no disciplinary hearing, it goes directly to inquiry by arbitrator, and the outcome has the same power as an award by the Education Labour Relations Council. So in that case, that collective agreement says that an intermediary must be appointed in each and every case involving a child witness under the age of 18. So the suggestion is that the intermediary still be in the room with the child, and then that the intermediary convey the questions to the child and then convey the questions back to the parties in the main virtual hearing room. And in this way, perhaps the intermediary could then also almost control the environment in which the child gives their evidence.
That's a great question. So the intermediary then, could one not argue that the intermediary is acting in a biased way if they're sort of helping the child?
Well, that's the general civil procedure, and then also specifically this collective agreement makes provision that the intermediary conveys the general meaning of the question. So it doesn't have to be the exact question. The intermediary acts in a way so that the child understands the question and can then respond to it. So in that case, it is considered valid evidence from the child's perspective.
Excellent. That's a great question. All right, we have time for one more, I think.
This is really just a very basic question. This is lack of my knowledge about the system in South Africa. What's the relation between this arbitration process and the process in the court? This is like a precondition to have the claim in the court. And the second one is this person who is performing this arbitration, or they are judges, or how they are appointed, how they are chosen, or how they come from?
That's a good question. Thank you for that. So the Labour Relations Act makes provision for the CCMA, which is a labour dispute resolution forum, if I can put it that way. And the CCMA has exclusive jurisdiction over certain matters such as dismissal, unfair dismissal matters. So it first has to go to the CCMA. It can later up in the labour courts depending on the process, but it has to go to the CCMA first. Then in the public sector and in other sectors there are bargaining councils. So the Education Labour Relations Council fulfills the same purpose as the CCMA, but in the education context.
We have time for one more quick question.
Oh, the training, sorry. The training, so CCMA commissioners and commissioners for the Education Labour Relations Council go through a training process. For example, my university offers a labour dispute resolution qualification where these commissioners are then trained to become commissioners at the CCMA.
Do we have any more questions?
Just a follow-up. Are the commissioners at the CCMA and the labor dispute, are they judges or are they they have no legal experience?
No, they can have legal experience, but some of them come from practice, some of them have been working at trade unions, for example, some of them have even have a background in human resource management, and if you then complete training as a commissioner, then you can be appointed as a commissioner. So they are not judges.
Okay, everyone. Can we give Dr. de Villiers another round of applause?